Good day. We will be discussing separation and termination of employment learning outcomes, Chapter 12. After reading this chapter, students should be able to cite the difference between just cause and authorized cause of termination. Describe due process and context of termination of employment. Discuss and explain the provision of Labor Code of the Philippines and termination of employment and retirement from service. Terminating an employee in the Philippines is taken very seriously and can be a complex process, especially after the employee is regularized Article 285 of the Labor Code. If the resignation is without cause, the employee is required to give 30-day advance written notice to the employer to enable the employer to look for a replacement to prevent work disruption. Dismissal of an employee in the Philippines. Dismissal of an employee in the Philippines. The employer may terminate the service of an employee for just or authorized cause after following the procedure laid on by the law. But the employer has the burden of providing lawfulness of the employee's dismissal in the proper forum. Dismissal of an employee in the Philippines. The employer may terminate the service of an employee for just or authorized cause after following the procedure laid down by the law. But the employer has the burden of providing the lawfulness of the employee's dismissal in the proper forum. Installation of labor-saving device, redundancy, retrenchment, and closure or cessation of operation, Article 283 Labor Code. Before the employer can terminate employment on the ground of disease, he must obtain from competent public health authority a certification that employee's disease is such a nature and at such a stage that it can no longer be cured within a period of 6 months, even with medical attention. Those hired on temporary basis, that is for a term or for fixed period, are not regular employee but are contractual employees. Consequently, there is no illegal dismissal when their service are terminated by reason of the expiration of their contract. Lack of notice of termination is of no consequence because of contract for employment for a definite period terminates by its own term at the end of such period.
There are two causes of termination. The first one is the just cause and then the other one is the authorized cause. When we say just cause, it refers to a wrongdoing committed by the employer or employee. It also says that it gives right to discipline and terminate an employee for their misconduct and negligence. And another reason for termination is that if they have violated some of the company's rules and policies. And those who are aggrieved are the one who has the right to complain and apply case for termination. Then the next one is the authorized cause. It refers to a cause brought about by changing economic or business conditions of the employees. The main reason of termination with authorized cause is because of economic or business condition that is not arising from the negligence of an employee. It is only based on the business matters or business conditions. Then, let's talk about the just causes for terminations by the employee. The first case given is the serious insult by the employer or his or her representative on the honor and the person of the employer. This is when you are being abused and bullied through your physical and also with your performance. The next one is inhuman and unbearable treatment accorded the employee by the employer or his or her representative. In this case, the employer is pushing the employee to do something wrong or to do something inhuman. For example, is through sexual harassment. Then the next case is the commission of crime by the employer or his or her representative against the person of the employer or any of the immediate members of his or her family. The employer uses force against the employee, but not only against the employee, but also including the employee's family members, like murders and kidnapping. And lastly is the other analogous causes or similar causes from. Then let's proceed to the authorized cause for termination. The first case is the installation of labor-saving device. It contemplates the installation of machinery to affect economy and efficiency in the method of production. Here, for example, is in a laundry shop. They lessen the labor work by providing automatic machines or washing machines, dryers, yes. Then the next case is redundancy. It exists where the services of an employee are in excess of what is reasonably demanded by the actual requirements of the enterprise. And then the next case is the retrenchment to prevent losses. It is an economic ground to reduce the number of employees. It is the reduction of personnel to the purpose of cutting down the cost of operations in terms of salaries and wages. Then the next case is the closure and cessation of business. When we say closure and cessation, it means that it is shutting down of the business. And it is also one of the grounds for the termination of the services of an employee. Maybe because of business failure, poor management, and insufficient capitals. And the last case is the disease not curable within 6 months. An employee may terminate the services of an employee who has been found to be suffering from any disease. Because continuing work while suffering from that disease might be prohibited by the law. It is done not only for the safety of the employee itself, but also of his co-workers or co-employees. Then let's proceed to due process in the context of termination of employment. When we say due process, it is the right of an employee to be notified for the reason of their dismissal or termination. It serves as the tool for the fairness on the procedures and the legal matters. And then when we will talk about the just cause, due process is used to provide the employees an opportunity to defend themselves. And then while in authorized cause, due process is a written notice. It is a written notice of their dismissal. It involves the reasons or grounds of the termination of the employee. And it must be given at least 30 days before the date of the termination.
Okay, so I'll be talking about the labor code of the Philippines, which is in the book 6. So, the labor code of the Philippines is the legal code governing employment practices and labor relations in the Philippines. It prohibits terminations of employment of private employees except for just or authorized cases as prescribed in the Article 282 to 284 of the Code. The Labor Code of the Philippines is a decree instituting a labor code by revising and consolidating labor and social laws to afford protection to labor, promote employment and human resource development, and ensure industrial peace based on social justice. I'll be talking about Article 279. So, Article 279, it's about security of tenure. It means that in cases of regular employment, the employer shall not terminate the service of an employee except for a just cause or when unauthorized by this title. So it simply means that here in the Philippines, terminating an employee in the country is taken very seriously and can be a complex process. Employers can dismiss the employee based on just and authorized causes if there's a good reason, a just reason, or a just cause. Then an employer can dismiss an employee. Or willingly, if the employee is not comfortable with his or her job and wants to voluntarily resign. As we move on to Article 280, it's about regular and casual employment. When we talk about regular and casual employment, it says that the provision of written agreement to the contrary, notwithstanding and regardless of the oral agreement of parties, an employment shall be deemed to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. So, in Article 280, meaning that when a regular, like, because there are two, regular employee and casual. So the casual employee is like rendered at least 1 year service in the same company where such service is continuous or like broken. For example, like a maintenance worker. And then we have the regular employments. It's like for example, it's like a shoemaker in the company. Those who are engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. So their Article 280 regular and casual employment is already explained, but both of them are rendered at least like 1 year of services. With respect to the activity in which he or she is employed, and his employment shall like continue while such activity still exists. So let's move on to Article 281. Article 281 is about probationary employment. Okay, when we talk about probationary employment, it's it's uh it shall not exceed 6 months from the date the employee started working unless it is covered by an apprenticeship agreement stipulating a longer period. Moving on to Article 282, it's termination by employer. An employee may terminate an employment for any of the following causes. We have serious misconduct or willful disobedience by the employer of the lawful orders of his employer or respective in connection with his work. If there is some misconduct or if the employee disobeys the employer, then the employer has the right to terminate the employee. Then we have the gross habitual neglect by the employee of his duties. If you're posted to do a job and if you neglect that, then the employer has the right to terminate the employee. Then there is fraud, as we all know what fraud is. So if you do a fraud in a company and your boss finds out, then he or she has the right to terminate you. And also, if commission of a crime or offense by an employee against the person of his employer or any intermediate member of his family is duly authorized representatives, then your boss can terminate you if you do a crime or if you offend his family members or maybe a business partner. Then he or she, as an employee or your boss, has the right to fire you. Then the last one says other causes analogs to the foregoing. Okay, so there we have it. That's all. Moving on. As we move on to Article 281, it's about probationary employment. Probationary employment shall not exceed 6 months from the date the employee started working unless it is covered by an apprenticeship agreement stipulating a longer period. So when we talk about the probationary employment, it's like an appointment that is made to afford the employer an opportunity to observe the fitness of the probationer while at work and to ascertain that if whether he or she will become a proper fitness of the job while at work.
The next article is article number 283 entitled Closure of Establishment and the Reduction of Personnel due to some reasons. The first one is the labor-saving devices. So nowadays, we have many scientific inventions who are so high-tech and then are capable of doing what people are capable of. So the employee are getting terminated because we have that labor saving devices. And the other one is the redundancy. What is about redundancy? So redundancy is about an employer is no longer needed because his job or her job is no longer needed. So due to those cases, those redundancy and labor saving devices, they have a separation pay equal to 1 month pay or at least 1 month pay for every year of service, whichever is higher. The next reason is about retrenchment. So what about retrenchment? So retrenchment is about reducing of employees, but here employees have no faults, but because an establishment can't give salary to those employees because they want to gain more profit. So in case of this thing, so they have the separation pay of 1 month pay or at least 1/2 month for every year of service or whichever is higher. This could be done unless the closing is the purpose of circumventing the provision of this title. So in case of that, they should serve a written notice to the workers as well as the Ministry of Labor and Employment within the intended date thereof. The next article is article number 284. So it is the disease ground for termination. So an employer may terminate an employee if he is suffering from illness that can harm him and as well as his co-workers, or this thing is also about when his employment is prohibited by the law. In this case, the employee can receive 1 month's salary or 1/2 month's salary of his service for every year or whichever is higher. The next article is article number 285, termination by the employee. So the employee may terminate without just cause the employee-employer relationship by serving written notice on the employer at least 1 month in advance. In case of the absence of that written notice, the employee may liable for damages. Employee may put an end to the relationship even without any written notice just because of this following just causes. So the first one is serious insult by the employer or any of his representative. The next one is inhuman and unbearable treatment accorded to the employee by the employer or any of his representative. The third one is the commission of a crime of offense by the employer or his representative, and other causes analogous to any of the foregoing. So the next
article is article number 286. So this one is when employment not deemed terminated. So say for instance, an establishment got suspended of its operation and they had employees. So if they got suspended for not more than 6 months, so when they get back, so the employees are getting back to their own position without losing any of their rights. So that includes their taxes and etc. etc. So in this case, the employer should give the employee his former position. So in this case, this not should be later than 1 month from the resumption of the operation. The Title 2 is about retirement from the service. The Article 287 about retirement. So, an employee may be retired upon reaching the retirement age. So, in case of retirement, so the employee shall be entitled to receive such retirement benefits under the law or under their agreement or contract. So, in this case, we have that compulsory retirement. So, what is this? So, in the absence of a retirement plan or agreement or contracts providing for the retirement benefits of employees in the company, and employee upon reaching the age of 60 years or more but not beyond 65 and who has at least served 5 years may retire and shall be entitled to retirement pay equivalent to 1/2 month's salary for every year of service, a fraction of at least 6 months being considered as 1 whole year, unless the parties provide for broader inclusions. The term 1/2 month salary shall mean the term 1/2 month salary shall 15 days plus 1/12 the 13th month pay and the cash equivalent of not more than 5 days of service incentive leaves. So, the service and agricultural establishments or operations employing not more than 10 employees are exempted from the coverage of this provision. So, violation of this provision is hereby declared unlawful and subject to the penal provisions under Article 288 of this code.